Welcome once again to Lehto's Law. Here's Steve Lehto.
A couple people tipped me off to a story in Ars Technica written by John Brodkin. And it's an interesting case because a court has ordered a lot of people to do something. A lot of people across the U.S. Every ISP, Internet Service Provider, every ISP in America has been ordered to block 3 pirate streaming services. The ISPs have been ordered to block the pirate websites by any technological means available. And now the question, of course, is what kind of jurisdiction does a court have? And when the court issues an order like that, can they really just say every ISP in America do something? And we'll talk about that. A federal judge has ordered all internet service providers in the U.S. to block 3 private streaming services operated by some defendants who never showed up to court and hid behind false identities. The blocking orders affect a case involving Israel.tv, Israel-TV.com, and SDAROT.tv, as well as related domains listed in the rulings and any other domains where the copyright infringing websites may resurface in the future. The orders came in 3 essentially identical rulings issued last month in U.S. District Court, Southern District of New York. Each ruling provides a list of 96 ISPs that are expected to block the websites, including Comcast, Charter, AT&T, Verizon, and T-Mobile. But the rulings say that all ISPs must comply even if they aren't on the list, and that, of course, is an interesting question. The language is, it is further ordered that all ISPs, including without limitation those set forth in the exhibit, and any other ISPs providing services in the U.S. shall block access to the website at any domain address known today or to be used in the future by the defendants by any technological means available on the ISP systems. The domain addresses and any newly detected websites shall be channeled in such a way that users will be unable to connect and or use the website and will be diverted by the ISP's DNS, domain name server, to a landing page operated and controlled by the plaintiffs. That landing page cites the U.S. District Judge's order to block all access to the website service due to copyright infringement. And then it says, if you were harmed in any way by the court's decision, you may file a motion to the federal court in the Southern District of New York in the above case. So here's the thing. I am somebody and I sue somebody else. Plaintiff, defendant. Okay, I'm the plaintiff, I'm suing somebody else, they're the defendant. I'm talking about the parties to a case, right? So the parties to a case, once you serve the defendant, they file paperwork and so on, they are in front of the court. Plaintiff is in front of the court, the defendant is in front of the court. They are the parties to the case. It's important because it looks like they never actually got these parties in front of the court, but if they're properly served, they're considered to be in front of the court. However, the internet service providers don't appear to be parties to the case. I don't think they were being sued, and yet they've been ordered to do something. And so the question is, are they going to object? Will this be difficult for them to do, or do they just simply flip a switch and make it happen, figuratively speaking? We'll have to see. But the 3 lawsuits were filed by Israeli TV and movie producers and providers against several defendants who operate those websites. Each of the 3 rulings awarded damages of $7.65 million. And that case has been widely reported in certain circles. The orders also contain permanent injunctions against the defendants themselves and other types of companies that provided services to the defendants or could do so in the future, which include companies like Cloudflare, GoDaddy, Google, and Namecheap. In all 3 cases, none of the defendants responded to the complaints and did not appear in court. Defendants have gone to great lengths to conceal themselves and their ill-gotten proceeds from plaintiffs and this court's detection, including by using multiple false identities and addresses associated with their operations and purposely deceptive contact information for the infringing website, the rulings say. The defendants are liable for copyright infringement, and through the website, defendants have been rebroadcasting and streaming plaintiffs' original content. That's the problem. So here's the question. The judge ordered domain registrars and registries to transfer the domain names to the plaintiffs. The rulings include injunctions against third-party providing services used in connection with the defendant's operations, including web hosts, content delivery networks, DNS providers, VPN providers, web designers, search-based online advertising services, and others. Financial institutions also face similar bans on doing business with the blocked websites. The rulings directly target the defendant's monetary accounts, saying the plaintiffs shall have the ongoing authority to serve this order on any party controlling or otherwise holding such accounts until they have recovered full payment of monies owed to them, about $22 million, by any defendant under this order. This applies to PayPal, banks, and payment providers in general. And that's what's unusual about the case. Like I said, you got parties to a case, plaintiff and defendant. But the judge is now issuing an order to third-party ISPs and third-party financial institutions. And so when the judge issues an order from the bench, right? The judge is sitting on the bench and the judge issues an order. The order is actually reduced to a piece of paper, often entitled order. And it'll have the case caption at the top and a date and explain what the order is and a place for the judge to sign it. The judge signs it. The clerk stamps it. The clerk enters it with the court. True copies get issued to the parties. But imagine that you were not in court that day because you weren't required to be there because you weren't a party to the action. You're simply a small ISP up in Alaska. Okay? The question is, you're not on that list. At what point do you become liable for obeying that court order? And presumably they'd have to serve it on you and let you know that it applies to you. And it's an interesting court order because it says these people by name and other people who are not named. So, as you can imagine, there might be some pushback from some small providers who say, don't read Ars Technica, don't watch Lehto's Law, and now I'm being told that I'm in violation of a court order on a case in New York that I was never notified about. I wasn't a party to the action, and yet I've got to do this. Now, I'm not saying that the court doesn't have the jurisdiction to do that. I'm just saying that to me it seemed a little odd that an order gets issued and it applies to people who weren't there. Because there might be, and again, I'm not as up on the technicalities of the internet as many of the people in my audience are, like Nathan. You can answer the question for me if you want. But how difficult will it be for an ISP to block a bunch of addresses like this? Will it be difficult? Will it not be difficult? If it's easy to do, it's not that big of a deal. If it's a pain in the butt or costs money, I can see somebody objecting. And somebody could object and go, gee, I kind of wish I knew there was going to be a hearing about something that's going to affect me. So I could have at least shown up and participated. And again, keep in mind that your right to be involved in a legal proceeding is not necessarily because you object. Not necessarily because you want to fight it. Sometimes you simply want to participate. And it's not like you get a participation medal. But I've actually had situations before in a case where something is unopposed and my opponent shows up. And I'm thinking to myself, okay, there's a logical disconnect here. It's unopposed, but I have an opponent. What's going on? And I've actually said to somebody before, why are you here? And I'm just asking. I'm asking the general question. And they say, oh, I'm here because boom, 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 boom. And they have some good reason. And they go, we're not going to oppose. We're just going to let the judge, hey, we're here. And actually, that's better for me. Because if they weren't there, something happens, and these people get upset by it, they run back into court and go, we weren't even there, you know. We knew about it, but we didn't think that was what was going to. So it's better if they are there. But the fact that it appears they weren't, that's the issue I've got with this. So we'll see what happens and see if those entities can continue operating now that all their websites have been shut down. I don't know. I didn't actually watch any of the channels that were mentioned there. So no offense, but Israel.tv is not high up on my bookmark list. So what can I tell you? But Huigba D and Mark both sent it. And I apologize for mispronouncing Huigba D. I might be correct on that. I don't know. Hard to tell. But John Brodkin wrote that for Ars Technica. And every ISP in the U.S. has been ordered to block 3 pirate streaming services. That's a federal court order. You better follow it. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. If at first you do not succeed, blame your computer.